Daniel has lived in Georgia for 6 years. He came in on a visitor visa, the stamp in his passport valid for several years, so he assumed he had years to stay. What he didn't realize is that the visa stamp and his actual authorized stay are two different things, and the second one ran out a long time ago. Daniel isn't a real person. But this week, somewhere in Georgia, there's a real version of him. And 1,226 people just found out how much that difference actually matters. If you're a non-citizen living in Georgia, or anywhere honestly, with a visa overstay, a final removal order, a pending criminal charge, or even just an old immigration court case you haven't thought about in years, this is the video to watch before you assume you already know what happened last week. Because the headline everyone's sharing isn't the whole story, and getting the details wrong could mean missing exactly the kind of risk this operation actually reveals. Here's what actually happened. On August 7, 2026, ICE announced the results of what it called Operation Safe Community Atlanta. 1,226 immigration arrests across Georgia. That's the number every headline led with. But here's the detail that gets buried every time. ICE said 720 of those arrested had either a U.S. criminal conviction or a pending criminal charge. That leaves roughly 500 people outside that combined category, and ICE did not publish a full breakdown of who they were or why they were arrested. So no, this wasn't 1,226 convicted criminals. It also wasn't 1,226 random arrests with no criminal element at all. The truth sits in between, and the agency itself didn't fully explain that middle ground. This is an enforcement report, not a new law. It's not a court ruling, and it's not a new statute passed by Congress. ICE already had the authority to identify, arrest, and seek removal of certain non-citizens under existing federal immigration law. Nothing about that changed on August 7th. What changed is the scale and visibility of one specific operation. Officers arrested 5 people at a trucking company ICE described as known for employing unauthorized workers. But the release never said all 1,226 arrests happened at job sites, homes, roads, courthouses. And scheduled check-ins were almost certainly part of the picture too, just without a public breakdown. Now here's the part that actually matters most if you're trying to understand your own risk, or a family member's. An immigration arrest is not the same thing as a criminal conviction. A huge amount of immigration enforcement happens under civil law, not criminal law. Civil immigration law is about whether someone is allowed to remain in the country, completely separate from whether they've ever been charged with a crime. That's exactly Daniel's situation. No criminal record at all, but an expired I-94, the actual arrival record that controls how long a visit is authorized, regardless of what the visa stamp says, is enough on its own to create real immigration exposure. A visa overstay isn't a violent conviction. A pending charge isn't a guilty verdict. A final removal order isn't the same as a pending asylum case still working its way through the system. Lumping all of that into one group is exactly how rumors spread, and exactly how people either panic unnecessarily or relax when they shouldn't. If you're finding this useful, go ahead and subscribe because we're tracking how these enforcement operations are playing out state by state, and Georgia almost certainly won't be the last one this year. Let's talk about who's actually facing the sharpest edge of this, because the risk isn't evenly distributed. People with existing criminal convictions face outcomes that depend heavily on the exact offense, the plea, the sentence, and their specific immigration status. Not every conviction produces the same result, and even 2 charges with similar names can carry very different weight under immigration law. That's why a certified court record matters more than memory of what someone was charged with. People with pending charges are in a different, often misunderstood position. A pending charge means no conviction has happened yet. The case could end in conviction, acquittal, or dismissal. And ICE's own number of 720 combined convictions and pending charges together, without saying how many fall into each group. And then there's the group with final removal orders, where the process has already reached the point where the government may remove someone unless a stay, appeal, or reopened case changes that. Though ICE didn't say how many of the 1,226 fall into this category either. Here's where it gets genuinely important for a family that thinks its paperwork is in order. Picture Daniel again, But further along, he applies for asylum, receives a work permit, and updates his address with USCIS after moving. What he doesn't realize is that USCIS and immigration court are separate systems, and updating one does nothing for the other. If a hearing notice goes to his old address and he misses it, a judge can hold that hearing without him and issue what's called an in-absentia removal order, a decision made in his absence. His work permit and his USCIS receipts stay valid documents, but neither one answers the separate question of whether an immigration court order exists against him. That's the quiet risk sitting underneath a lot of cases that look fine on the surface. Not a new rule, but an old order, a missed hearing, or an address that was never properly updated everywhere it needed to be. Just as important is understanding who this announcement does not automatically touch. Anyone outside Georgia isn't part of this specific 1,226 figure. This didn't create a new nationwide rule. It doesn't mean every green card holder, visa holder, student, or asylum applicant in Georgia was targeted. U.S. citizens are not removable under immigration law, and that hasn't changed, though anyone questioned should stay calm and be ready to show proof of citizenship if needed. Green card holders aren't automatically protected either. Certain convictions or fraud findings can still create problems, but that's a far cry from every green card holder in the state being at risk. And no previously approved case, work permit, or visa was canceled by this announcement. Nothing about an already approved status changed because of this operation. So what should you actually do with this practically? First, gather your core immigration records now, before anything urgent happens. Passports, visas, I-94 records, work permits, USCIS receipts, court notices, and certified criminal records if any exist. Second, check directly whether an immigration court case exists using the Department of Justice's automated case system. And if what it shows doesn't match a notice you've received, get that resolved with a qualified representative rather than guessing. Third, update your address with both systems separately. USCIS has its own process, and immigration court requires its own update, generally within 5 working days, using its specific form. One does not cover the other. Fourth, build a basic family plan. A trusted adult who knows where records are kept, a lawyer's contact information written down, and someone who has the detained person's A number on hand, kept private, if the worst happens. Fifth, know your basic rights without creating new problems. Stay calm. Don't run. Don't resist. You can state you wish to remain silent and speak to a lawyer, and you can ask to see a warrant before opening a door to officers, remembering that a civil ICE administrative warrant is not the same as one signed by a judge. Let's clear up what's already circulating as rumor. This wasn't 1,226 convicted criminals. 720 had convictions or pending charges, and a charge is not a conviction. This also didn't create a new Georgia immigration law. It's a federal enforcement operation reporting its results, nothing more. And an arrest here doesn't automatically mean immediate deportation for everyone involved. Some people face faster action because of existing final orders. Others are only now entering a court process with real options still available. At the same time, don't swap panic for false reassurance either. This was a large, real operation. Detention can move quickly, and legal deadlines can be strict once a case is in motion. The honest position sits between those two extremes. This doesn't mean every immigrant in Georgia is at risk, and it also doesn't mean anyone with an unresolved issue should treat the news as irrelevant to them. Come back to Daniel one more time. Nothing about his situation involved a crime, a lie, or a decision to break the rules on purpose. It came down to a date on a form he never fully understood, sitting quietly in a file for years. That's exactly the kind of thing worth checking before an operation like this one turns it into an emergency instead of a paperwork fix. This video is for general information and educational purposes only and does not constitute legal advice. It reflects ICE's published announcement and reporting current as of August 10, 2026, and further details may still emerge. Every case involves different facts. Anyone dealing with detention, a final removal order, a pending charge, a missed hearing, or an urgent deadline should speak with a qualified immigration attorney or accredited representative as soon as possible. Follow for more updates like this one, and subscribe to the channel so you don't miss what's coming.